very happy to have you here for this, I think, important event. Things have transpired over the last few months and years that need to be dealt with, addressed and understood from a lot of different angles, from a systemic angle and from the angle of individuals. My name is Dr. Thomas McManus. I'm the Acting Director of the International State Crime Initiative. That is a research centre here at Queen Mary, University of London Schools of Law. State crime is briefly, very briefly, defined as organisational deviance that involves human rights abuses. The crimes we concentrate on are the crimes of the powerful, the crimes of governments and corporations. And by deviance, we mean something that may or may not be criminal, as in against criminal law or against regulatory law. And we use deviance because what we find is states don't often write laws to criminalize themselves, and if they do, they don't often enforce them. And similarly, they often don't write laws to criminalize corporations in a bid to attract corporations to their jurisdiction. We've been very concerned with the criminalization of resistance to state crime, of peaceful resistance to state crime. State crime theory proposes that in the absence of any formal legal justice systems, that it falls to civil society to step in, to censure and to sanction the behavior of states. And that's basically what we're talking about tonight. We're talking about that space. We're talking about, one, the crimes of the state, but we're also talking about the space in which we can sanction, censure and resist against that crime in the absence of any formal legal mechanisms that can do it on our behalf. We have a great panel here tonight. To my far left we have Gracie Bradley, who is a writer and campaigner interested in human rights, state racism. She is Policy and Campaigns Manager for Liberty. Formerly worked here at Queen Mary as well, so that made it easy for Gracie to find where we are tonight. Also to my left I have Ali Tamlit, part of the Stansted 15, a member of End Deportations and Playing Stupid. To my far right, Raj Chada, who's a partner at Hodge, Jones and Allen, and has acted for 15 defendants in the Stansted case and also represented 13 defendants in the Heathrow case. And it's quite interesting the progression we've seen between those two cases. And to my immediate right we have Dr. Joanna Gilmore, who is lecturer in law at the University of York, researching public order policing, human rights and community-based responses to police misconduct. So we have, we're going to be able to get a layered view of this whole situation from our panelists. I'm not going to speak for very much longer. Each of the panelists is going to talk for about 10 to 15 minutes, which will bring us to about 7:20, 7:30, and then we'll have 30 minutes for Q&A and discussion. And I'm very much looking forward to that part of the event, where we get to feedback to our panelists and have discussions amongst ourselves about what we understand is going on at the moment. There are no fire alarms scheduled, so if we do hear one, we should all calmly get out, get down the stairs and go out to the door, the main door you came in, and to the right of the Jewish graveyard we can muster. I don't think there's anything else for me to say, so I would like to call our first speaker to address the audience. Thank you.
Thanks. Thanks a lot for organising this event and for having me. It's great to be here. So I'm here from Liberty. Many of you will know Liberty. We're a very old human rights organisation, and I lead the organisation's work campaigning against a hostile environment, which is what I'm going to talk about mainly. But I also manage our policy work on counter-terror and policing, and you'll have to forgive me, I'm a bit tired because my boss is on holiday, which means that I got landed with learning all about citizenship law about 10 o'clock last night. But I think it's timely, so I'll try to bring us back to today's news as well, because I think they dovetail quite well. But I thought I'd start out with talking a bit about what the hostile environment is and what it isn't. Of course, there's kind of everyday meaning of hostile environment, the way in which politicians might use that term, the way in which media uses that term, especially post-Windrush. But from a policy perspective, the hostile environment is quite a specific set of policies introduced since 2010, aimed at making life so unbearable for undocumented migrants that they leave the country, essentially. So when the coalition government came to power on a manifesto pledge to reduce net migration to the tens of thousands, David Cameron, who we often don't hear associated with the hostile environment, set up an interministerial working group on migrant access to welfare benefits and public services. It was initially called the Hostile Environment Working Group, but the Liberal Democrats objected. So this is essentially a web of policies that's been enacted, first publicly referred to by Theresa May in 2012, and their aim is essentially to exclude undocumented people from essential goods and services, and to co-opt private citizens and public services into doing immigration enforcement. And so what you see is a move away from enforcement at the border into the heart of kind of public services and communities. It's important to caveat all of this with the fact that there were policies that were very similar in their structure to the hostile environment prior to 2010. So New Labour laid some of the groundwork for this. They introduced the obligation to check a person's immigration status when they were trying to work, for example, so workplace employer checks. And we see that logic then replicated in the hostile environment when we look at, for example, landlord immigration checks. So you have to have a right to rent to be able to rent a property. Driver's license, you have to have regular immigration status to have a driver's license. You have to have regular immigration status to access free healthcare in the vast majority of circumstances. But we also see a massive increase in data sharing between essential public services and Home Office immigration enforcement. So a kind of web of very secret data sharing agreements has been set up since 2012, again, exploiting processes that were in place before but not really used and kind of ramping them up to sweep in thousands of people. So now, if the Home Office wants somebody's address from a person's medical records, or at least until May this year, they could ask NHS Digital for that address. And that address would have been collected ultimately by a frontline health worker who would have put it on a database. It would have gone to NHS Digital, and that address could then be taken by Home Office immigration enforcement without that frontline worker knowing about it. That agreement has been suspended, but similar agreements operate in education, so children's school records are being used for immigration enforcement, and every time an employer or a landlord or a hospital has to check someone's entitlement, when they check that with the Home Office, they obviously end up giving a person's name and their address and other things, so if that person is undocumented, they're then flagged to the Home Office. The Home Office didn't already know about them. So we see this massive web of data sharing that's been essentially erected in secret. It's taken lots of FOIs to get those data sharing agreements out of various public services. There's been no parliamentary scrutiny, and essentially a lot of the frontline workers that collect that data have had no idea that they were being made complicit in immigration enforcement. The last thing that we see, though, are increasingly civil and criminal penalties for non-compliance. So there is now a criminal offence of working illegally. There is a criminal offence of driving while unlawfully in the UK. An employer can face a fine of up to £20,000 per undocumented worker. They can also face criminal penalties for employing undocumented people, and landlords can face criminal penalties for renting to undocumented people. So as I say, the aim was really to make life so unlivable for undocumented people in the UK that they leave. The actual effects, though, are essentially not that. Quite an interesting study that was done by academics at Oxford University found that there's little evidence to show that voluntary returns have increased since the introduction of the hostile environment. What we do know, though, is that it's obviously increasing destitution, it's making people ill, it's pushing people into the arms of abusive landlords, abusive employers, and so there have been really high-profile cases of, for example, people who have experienced sexual violence, who have been afraid to report that to the police for fear that their data would be shared with immigration enforcement, and those fears were justified. Over half of police forces have shared data on victims and witnesses of crime with immigration enforcement. There was a woman who went to the police to report sexual violence, and she ended up being arrested at a rape crisis centre on immigration charges herself. We also know from bail for immigration detainees that they saw a man who had been assaulted, hadn't wanted to report to the police, was compelled to report it to the police then arrested him, he ended up in detention, he hadn't had any medical attention. We know that there are children and families who are scared to be in school. We know that there are people who've been charged tens of thousands of pounds for palliative care. We know that there are people who've been wrongly denied access to abortion services, who've had to then go through with pregnancies because they couldn't afford charges that were levied against them. So that's the impact on undocumented people. The hostile environment, it is a human rights issue. But I would add that, of course, what it does is it funnels people into detention because it widens the net. It gives the state an opportunity to gather more data on undocumented people. So you see more people in detention, more people potentially subject to removal, although that doesn't look like what's happening in terms of voluntary removal. But if we step away from thinking about undocumented people, of course, if you are asking kind of private citizens and public servants who know nothing about the immigration system to do immigration enforcement, of course what you get is a generalised climate of suspicion based on who seems to be foreign by virtue of their name or their accent or their skin colour. And we know, for example, from the Joint Council for the Welfare of Immigrants, they did some research that showed that actually 58% of landlords were less likely to respond to a query from a black or minority ethnic person who didn't have a British passport. So we're encouraging a climate of discrimination, but of course also it's warping public services. And it's undermining other public policy objectives, like public safety. Everyone has an interest in crimes being reported. Like public health, everybody has an interest in people being able to go to the doctor as soon as they're ill and not waiting until they need to go to A&E. And of course, children's education, because that isn't just to do with kids needing an education there and then, it's to do with essentially their entire life chances. But I think Liberty's other concern around the hostile environment is that ultimately it's increasing state power over everybody. It's kind of conditioning everybody that, yes, we need to show biometric ID when we do something as mundane as go to the doctor or try to rent a property. It's essentially kind of paving the way for a system of ID cards by the back door, and we're concerned about that too. But I wanted to make the link a little bit to what's going on in counter-terror. Because we've seen similar things, we're seeing similar things in counter-terror, we're seeing similar things in gangs policing, so essentially kind of assigning someone a suspect status, whether it's undocumented migrant or gang nominal or suspected terrorist, and then using that status to essentially co-opt public services into surveilling that person or viewing them with suspicion, but also slapping criminal penalties on what are fundamentally non-criminal activities. So if you look at gang injunctions, you'll see that kids have been criminalised for doing things like wearing a hood, because that was one of the conditions of their gang injunction. In the counter-terror sphere, the most recent counter-terror bill criminalises you for looking at content that's deemed likely to be useful to a terrorist online, even if you have no terrorist intent. It criminalises travel to a particular area overseas, again, even if you have no criminal intent. And we've also seen kind of a ratcheting up of the rhetoric when it comes to counter-terror. We see the state really cracking down on dissent when it comes to things like, I don't know, human rights groups saying that they have concerns about Prevent. You know, we were told critics of Prevent side with extremists. But we know that Prevent has produced discrimination and is facilitating suspicion of ethnic minority and Muslim people as they interact with public services. It's not, it's not a controversial thing to say, but the rhetoric from the government is really, really hot. So I suppose the other thing I wanted to touch on though, because I've been thinking about citizenship stripping, is kind of this thing about what preceded the hostile environment. So I touched a little bit on policies that were similar in their structure, like workplace immigration checks. But of course what also preceded the hostile environment in the New Labour years was increasing recourse to exclusion powers to deal with what were criminal justice issues. And so when I think about citizenship stripping, that power has existed for decades, but it's progressive changes to the law in 2002, 2006, 2014 that have made it much, much easier for Home Secretaries to strip people of their citizenship. And it's those years that have seen the biggest increase in the use of citizenship stripping powers. Similarly, it was, I think, post-2011 that we saw a really big ratcheting up in the use of charter flights, mass deportation flights, which obviously Ali will talk about. It's the 2007 Borders Act that introduced the automatic deportation provision. So if someone's convicted of a crime and they have to serve a sentence of 12 months or more, they have to be considered for deportation automatically. So the kind of recent decades have seen increasing recourse to the immigration system and powers of exclusion, exile and banishment as the answer to or double punishment for what are essentially criminal justice issues. And the impact of that is obviously racialised, because who has a foreign parent and is vulnerable to having their citizenship stripped, or who is likely not to have British citizenship but maybe have grown up here or whatever, that's racialised. But this kind of stripping, progressive stripping away of rights, I mean, it's not even just to do with kind of New Labour. It didn't start then. When you look right the way back to the beginnings of the Windrush scandal, I mean, that's what immigration law in the UK has done. It's progressively stripped rights from a particular class of people. So anyway, I suppose, in conclusion, the thinking that I've been doing today and over the last couple of months, and observing kind of the fact that people are increasingly interested in the fact that, people are being deported when actually they grew up here, or people are being stripped of their citizenship when actually they grew up here. I think what is really important to reiterate is that appeals or kind of opposition to those practices that are based purely on appeals to Britishness are inadequate. Because there are always going to be people who don't have that proximity to Britishness. And I think it's really important to reiterate that essentially the immigration system and immigration powers, exclusion powers, shouldn't be used as a substitute for due process. And I suppose that's what an awful, and essentially that we need to raise the bar for everybody. So when we think about the Shamima Begum case, we should be saying, yeah, it absolutely is racialised and discriminatory that she can be stripped of her citizenship, whereas, well, I think actually technically I potentially could, but someone who was totally British, born here, parents were British as well, they couldn't be. It's right that we raise that, but we also need to problematise the idea that exiling anybody, whatever their nationality, is an adequate way of dealing with this. And similarly, when we talk about foreign national offenders, we can't just talk about the people who grew up here who shouldn't be doubly punished. We should be talking about the fact that it's unacceptable to doubly punish anybody, whatever their immigration status. So yeah, I guess that's what quite a lot of my work at Liberty is concerned with, and hopefully we can talk about it a bit more later.
Thank you very much. And we will have lots of time for questions at the end, so store them up, write them down, keep them in your mind. I just want to say that Helen Brewer was to join the panel as well, but she is unwell and sends her apologies. So now, I'll turn over to you, Ali.
Great. Well, thanks everyone for coming here. It's really nice to see lots of people interested in this event. So my name is Ali, and I'm up on that photo. I'm one of the Stansted 15, and I guess why do people know who we are is a good question. So back in 2017, on March the 28th, the 15 of us got in a minibus. We drove to Stansted Airport. We hopped out right by the fence. 6 of us had bolt cutters. We cut a small hole in the fence. We casually went through. We were carrying lots of equipment. We walked about 150 meters across some grass up to a parked plane, a Boeing 767. It was parked, getting ready for flight. And we got there. We were in 2 groups. 4 people went round the front wheel, locked their arms together in a ring around the wheel so it couldn't move. The rest of us went to the back of the plane, behind a wing. We put a tripod up. We locked ourselves around the tripod, and Helen, who's not here, was sat on top of the tripod. And we were there for 10 hours. The police were there about 5 minutes after we were there, but we were already, all but one of us were already locked down. And we stayed there as long as we possibly could. We had metal tubes and chains holding us in position so that that flight couldn't take off. Why would we do such a thing? Like, why would you go and break into an airport? That seems quite extreme. We were there because that flight was a charter flight. It's a mass deportation that the Home Office had scheduled to Nigeria and Ghana that night. And we had heard the stories of 3 people via the Detained Voices blog. They're a collective that are in contact with people in detention centres across the UK, and all they do is, with their consent, they ask for their stories and they just write it down. They transcribe it word for word so that their stories, which are so hidden from the world, can be shared. And 3 of those 3 people got in touch with Detained Voices before that flight, said that they were due to be on that flight, and they said for various different reasons that they were scared for their lives. While we were driving to the airport, we reread those testimonies out loud, so we were like really sitting with like, these are real people we are going to try and intervene for. One which sticks in my mind the most is a lesbian woman who lived here for a number of years. She was forced to marry a man in Nigeria, and he had got in contact with her and said that he knew she was about to be deported, and that if she was deported, he would meet her at the airport and kill her. Not only did she face that, but being an out lesbian, that's illegal in Nigeria. You can be imprisoned for 14 years for being gay, which is a legacy of colonialism, British colonialism. And yeah, we were really, really worried about these people. So we knew, like, people have been campaigning around these issues, have been writing to MPs, we've all been involved in different protests. It's really, really hard to get someone off a deportation, and we decided that the most effective way to stop that would be to stop that plane. So that's what we did. And that night, the plane didn't take off. We were finally cut out. 10 hours later, early in the morning, we were taken to a few different police stations around the county of Essex, and we were charged with criminal damage, aggravated trespass, and some airport bylaws. All of which, the worst that could have happened would we get 3 months in prison. Another reason we were there is not just about these people, but it was the broader policies of charter flights. They're a thing that happen quite regularly. They, on about a monthly basis, they go to different countries: Pakistan, Nigeria and Ghana, Jamaica, Albania. And these form part of the government's hostile environment. They are kind of a response to deportations can happen on normal planes, like that you and I might go on. They'll have the person deported like at the back of the plane with 2 guards next to them. But if that person screams and shouts and gets the attention of people on the plane, it's possible to resist that. I don't know if people saw the Ellen Erson, who recently also didn't go to prison. That's really easy to stop those flights, like stop those deportations. So they try and stop people resisting by having these charter flights where there's no one else on the plane. There's deportees, maybe 50, 60 deportees, and then 3 guards there restraining them, often in shackles. The conditions there are horrific. The inspectorate of Her Majesty's Prisons Inspector says that the use of restraints is excessive. when it should be like the exception. Like when he calls these things out, who is not like a radical lefty, you know something's wrong. And part of the reason for the charter flights is they say it's more efficient, it's more cost effective. It's not true. But they've got a whole plane, so they put themselves under this pressure to fill a plane. So then they have more raids, this idea of perceived nationality. They go looking for people that think shouldn't be here, round them up, detain them in the weeks before the flight, and then try and get them on the plane. And not only do they know that this is like not a good practice, and they know that people get last-minute injunctions against it. So not only do they take the number of people they want to be deported, they take 50% extra. So 50% of people will be on a coach, shackled, go to the airport, think they're going to be deported, but then come back and could go through that a number of times. That's a really traumatic experience to put people through, let alone like the thought, yeah, just that's a disgusting thing, I think. So anyway, we did that, we got a charge, we went away. Sometime later, the charge increased to what we were eventually put on trial for, which is, I think Raj will talk about that more, but it's a terror-related offence. We went from 3 months in prison being the worst case to life in prison being the worst case. That in some ways that's really unprecedented. That's like quite shocking. It's part of like a wider trend of cracking down on migrant solidarity that you can see across Europe. People who are on boats trying to rescue people in the Med, people who are assisting people across borders on the land are getting prosecuted. So there's a trend, and I think that is really worrying, and I think we should be worried about it. But it also, I've been like looking at other cases more recently, and it's not actually, in other ways, the state always tries and cracks down on people. I was looking at the Bradford 12. In 1981, there was going to be a fascist march through Bradford, and local organizations were mobilizing against it. Some people decided that they would prepare some petrol bombs just in case they needed to defend themselves. They also got done with an endangerment offence, which is similar to ours, and they won their case. They won the right to self-defense. So I think it's like, that's good that they won, but it's also like, we can see this case as part of a wider legacy of like cracking down on people who try and resist racism and anti-fascism. I want to talk about the idea of the Stansted 15. At first I really didn't like the name, the Stansted 15. I don't like being seen as this thing and like being put in the media as, yeah, a thing. But it's not only like the media who've created the Stansted 15. I think the state, in a way, have created the Stansted 15. And I don't mean any of us are undercover cops or anything. Like, we're all, as far as I know, real people. But I think by criminalising us and by putting a higher charge on us, the interest has grown. When we did the action at first, people were like really interested. There was like some newspaper attention, but then it all died down quite quickly. And if we had been charged with aggravated trespass, there would have been like a few articles about it. But once we got called this like terror charge, and more interest grew, and when we got found guilty, even more interest got built, and it just seems to grow and grow and grow the more they try and push down on us. And I think that's quite interesting. I think there's people, yeah, I think it's interesting. I think they could shoot themselves in the foot. I think there's a risk of making martyrs out of people. So I think I think they were quite smart in not sending us to jail, because they would have created martyrs out of us. But I think it's just really interesting that they have created us with their repression. And yeah, there's a lot to think about that. Some people who are involved in activism might want to use that to gain more attention. I personally wouldn't choose to do that, but it's interesting that that is the response that happens when they try and crack down on you, which isn't to say let's let them crack down on us some more. I'd rather they didn't, but when it happens, it tends to backfire. Yeah, I wanted to talk about the day of sentencing. So about 2 weeks ago now, we were sentenced. Some of us were expecting to go to jail. I had broken into an airport before, so I was expecting to go to jail. Thankfully I didn't. And it was a really like mixed day. It was a day of really mixed emotions, because on one hand we didn't go to jail. That is seen as a win, but is it a win? Because we'd already lost the case, and by saying it's a win, it's kind of like saying, well, a suspended sentence is like a reasonable response for this action, or 250 hours of community service. That seems like a fair deal for like what we did, this crime. Is it, isn't it? Like, these are questions that I've got in my head. Another reason the day was like quite a mixed day was because it wasn't just our sentencing, but that very morning a charter flight went to Jamaica. That was the first charter flight to the Caribbean since the Windrush scandal. And there hasn't even been like a full report into understanding the Windrush crisis. So how can there have been any learnings about that when it hasn't been published? You can't carry on doing something you think you've, like, if you think you've done something wrong, you need to sit down and learn about it before trying to change your behavior. They haven't learned from anything. At least 14 people died because of wrongful deportations during the Windrush scandal. So that seems like some serious things they need to consider before restarting a policy. Another reason that it was like a mixed day was because there's a real tension in the media. We are presented as heroes a lot of the time. People like to celebrate us as like good people and don't think we deserve punishment. But then we have like a real contrast between like good criminals who don't deserve punishment, bad criminals who deserve jail and should be punished. But like my position is like, I'm anti-prison. I don't think prison is good for anyone, and I think we can do a lot better than it. But we have to like really work with these like tensions between like good criminal, bad criminal, good migrants who come here and work hard and contribute to society and create economic growth for us, and bad migrants who are here to like scrounge off us or something like that and just want to have a nice life, or even like refugees who are deserving, and people who want like an economic reason to be here and just want a nice life. Like, I think everyone has the right to live wherever they want and to have a nice life. Me with a British passport, I can pretty much live wherever I want and maybe find a job or maybe just sit on a beach. Like, that privilege should be extended to everyone, I think. Yeah, so I just wanted to end by saying it's really confusing. It's like an end of a horrible process for us, but the wider struggle needs to continue. I hope that the Stansted 15 can step aside, step out of the spotlight, and in a trying way of doing that was last week we organised a week of action. Some people blockaded the Home Office. We had a public trial outside the Home Office. The public put the Home Office on trial, and unsurprisingly we found them guilty of a lot of things. So I hope we can continue to sentence them to more campaigning and more direct action to change their policies. Thank you.
Thank you very much. And now, Mr. Chada.
Thank you. I was Ali and 14 others solicitor, and I acted as an advocate for two of them in court. And I'm going to talk about the legal context, but I'm going to start with a personal reflection on Stansted and what happened. And the two moments that I recall is I was at the back of the court and closest to the defendants. We got the note that verdicts were there. No matter how long you do this job, that moment when the clerk comes to you and says we've got verdicts, it's a terrifying moment for the lawyer, let alone the defendant. I have to say, the jury had not been out that long, and that was a sign of the worst. But I looked back at the 15 clients in the dock, and they were all holding hands, their hands raised, as they waited the foreperson of the jury to unfortunately say that word, guilty. But that moment where the defendants were joined together was touching in court, and was a point of their element of solidarity with each other and their element of solidarity with the cause for which they chose to be tried. And the second was during sentencing a couple of weeks ago, where I read out the testimony of some of the individuals who were on the plane that didn't take off, or were going to be on the plane that didn't take off, but had stayed in the UK as a result of Ali and the others' actions, including one individual who said that he was there for the birth of his child, and that he now had settled status in the UK, and that in effect the Home Office had got it wrong, and that he was in this country solely because of the actions of the Stansted 15. And whilst I will talk a little bit about the law, those two incidents remind us that behind all of this, it's about the individuals. It's about the individuals of Stansted 15, it's about the individuals that were being deported that night, and are the victims more generally, as has already been spoken about the hostile environment. Now, for the law, well, Ali's talked about the fact that originally the defendants were charged with aggravated trespass. They had their first appearance in early April 2017. I recall going, and I recall getting the original prosecution paper, sort of 2 or 3 page summary of what had happened. And these days the prosecution put a little note at the top of what the expected plea is. And they put guilty. And I said, I don't know why you've put that, because my clients are all pleading not guilty, because they were justified in doing what they did. And the CPS lawyer was entirely shocked that such a thing could be construed. And I'll talk about justification shortly. But pause for a second. Had the clients chosen to plead guilty at that opportunity, they would have got conditional discharge. They would have got a warning from the court. And that would have been the end of it. Little did we know, 3 months later, we get a communication from the CPS to say they were going to change the charge to one under the Aviation and Maritime Security Act 1990. No further evidence had come to light. There was nothing additional that the CPS had to consider, but someone, somewhere, in some room, decided to change the charge. And as Ali says, it went from a 3-month maximum to a life imprisonment maximum offence. Now, throughout the trial, one of the issues that was alive was what's the nature of this offence? And since sentence, the CPS have come out really strongly in the press to say this is not a terrorism offence. Hodge, Jones and Allen, Mr. Chada is misquoting things, and this is not a terrorism offence. They are right on one level. It is not a terrorism offence under the Terrorism Act, as defined the Terrorism 2000. But we've never said it was, and it's a bit of misdirection. What we have said throughout in the court and in the press afterwards is that it is a terror-related offence, and it implements an international convention to deal with terrorism, and it shouldn't have been used against protesters. I'm just going to read out the section because it's quite helpful just to remind ourselves as to what the defendants were charged with. So, it's an offence for any person by means of any device, substance or weapon unlawfully and intentionally to disrupt the services of such an aerodrome in such a way to endanger or likely to endanger the safe operation of the aerodrome or the safety of persons at the aerodrome. That's a really, really widely construed offence. It can be made out in a number of of different ways. So you have to go back and say, what is this offence really about? And you look at the introduction, which says, this is an act to give effect to the protocol for the suppression of unlawful acts of violence at airports. So it's called the Montreal Protocol. That's what this act was intended to do. It's about implementing something called the Montreal Protocol about unlawful acts of violence. And when it was being introduced into legislation, the minister, I think it was Cecil Parkinson, said, one of the hallmarks of this government has been their determination to stand firm against the terrorist. We have never shied away from taking measures necessary to crush the threat of terrorism, be it on the international stage or at home. This bill will be another valuable weapon in that battle. It will combat international terrorism in the sky and the sea. They then refer to what was then Clause 1, but became Section 1, which is the offence which Ali and the others were charged under. And he says this, he says, Clause 1 deals with what are essentially terrorist acts at airports. It enables the government to ratify the Montreal Protocol. So there can be no doubt what the purpose of this legislation was. And yet, throughout the case, the prosecution maintained it had nothing to do with, initially they said it was nothing to do with the Montreal Protocol, until they were referred to the introduction of the Act, and still maintained that it was nothing to do with terror-related legislation. The final point of that, just to add to everyone's woes, is that under Section 6 of the Terrorism Act 2006, it is an offence to encourage or entice others to commit what's called a convention offence. This offence, the one that Ali has been convicted of, is a convention offence. It's specifically defined as a convention offence under the Terrorism Act 2006. So if you encourage or condone what the Stansted 15 did, many of us in this audience, in this room may say was right, potentially you are guilty of an offence under Section 6 of the Terrorism Act 2006. Now I know that nobody's going to be prosecuted under that, but it highlights the ridiculous nature of the charge in the first place. It highlights how over the top the prosecution treated this offence. It is very widely drawn, that offence. And so, one of the safeguards is that you have Attorney General consent. So the Attorney General has to consent before a prosecution under this legislation, under this particular section, is drawn. And indeed, that was referred to during the debate in Parliament, in which it was pointed out that all of these offences were very widely drawn, and the Minister allayed concerns about the possibility of charges being brought beyond the scope on the express basis that the prosecution would only be brought with the permission of the Attorney General. And one of the examples, not under Section 1.2, was, well, what happens if there's a commission of the breach of the peace? Test in effect. And they said, well, don't worry, the Attorney General wouldn't give consent in those circumstances. In this case, the Attorney General did give consent. One of the other arguments that we pursued throughout the course of the trial was it was an abusive process, that the Attorney General should never have given consent or give consent erroneously. And this is just a sort of little vignette of how the state treated the Stansted 15. So there are various cases which set out the criteria by which the Attorney General should consider whether or not to give consent. But there is also a document which is called, unsurprisingly, the Consent to Prosecute - Legal Guidance. And it was published on the CPS website. and it lists the criteria by which the Attorney General should consider. And I'm not going to go through all the criteria, but by and large what it says is you have to consider whether it's appropriate to charge, and you have to consider what the mischief of the act was. Particularly important, you might think, in this case, where the mischief was about terrorism. So that guidance says you have to actually look at what the mischief is. So we say, during the course of legal argument, we want to know what went to the Attorney General. What information was the Attorney General aware that this legislation implemented the Montreal Protocol, was about terrorism, and how can he justify this issue about mischief? We didn't get anywhere in court, but defendants were convicted on the 10th of December 2018. 11th of December 2018, the CPS guidance disappears from the website and is changed. No reference to what's called the Franks Committee, which sets out what the criteria is. No reference whatsoever. I have no idea why. Could be coincidence. Luckily, we have our old copy in digital storage, but it's quite remarkable the extent to which the state as a whole sought to prosecute this case. And you saw it in court. You saw it in court where in a normal criminal case these days, you have your barristers, and that's about it, because there isn't money for anyone else. But they had a Home Office barrister there every day. They had 2 fairly senior officers there every day for 10 weeks, all to prosecute the Stansted 15. I'm running out of time, so the last bit that I'm going to deal with is that defence that I related to, which was that justification at the start. So there are 2 elements to the defence of justification. Number 1, we did what we did because we were seeking to prevent another criminal offence from happening, assaults on the plane by security staff and so on. Or number 2, we did what we did because we had a reasonable belief that death and serious injury would result if we didn't act in the way that we did, and we acted reasonably throughout. So we had a genuine, honest belief that the individuals on the plane were going to be harmed when they went back to Nigeria or Ghana, so we had to make sure that plane didn't take off. That defence was withdrawn from the jury by the judge. It's highly relevant to what the chair said about, well, what happens when it's the state that colludes and is complicit with the actions in the first place? The answer, we haven't got the full reasoning yet, is broadly, well, we live in a democratic society, and you must take your grievances through the democratic process. That's insufficient in our view, and that's part of our appeal point. But there are occasions in which direct action is highly relevant because it was the Home Office that was breaking the law on these flags, not us. And all we were doing was seeking to make sure that the government complies with the same set of rules and the rule of law as everyone else. And we're very keen that that matter is ruled on by the Court of Appeal. So there are other matters. There were so many other things that happened during the course of the trial that I'm sure will come out during Q&A. But I'll end with, I know Ali in particular shies away from being thanked, but we should thank him. We should thank Stansted 15 about the action that they took. And going back to the issue of individuals, it was a huge personal cost to them of living under that type of offence and the threat of imprisonment for over 2 years. So thank you very much.
I'm just going to set up some slides.
I haven't moved it for 17. because he was off camera.
Thank you.
But I only realised towards the end, sorry.
That's all right, don't worry.
Okay, so I'd just like to thank Tansel for organising the event and for the invitation to speak. I'm a lecturer in law at the University of York. I've been researching the criminalisation of dissent for several years, including the policing of anti-war, anti-fascist and more recently anti-fracking protest. And alongside Tansel and some other activists, I was a founding member of the Northern Police Monitoring Project, which is a campaigning and advocacy organisation based in Greater Manchester. And in this brief talk, I'd like to try and draw some links between the experiences of the Stansted 15 and the criminalisation of dissent more generally, drawing in particular on the ongoing research project into the policing of the anti-fracking movement. But before I do that, I want to take a step back a little further in time, because in a couple of weeks we're going to be marking the 35-year anniversary of the start of the miners' strike back in 1984. And when we're thinking about the policing of dissent, and by that I don't just mean the actions of the police, but the whole process by which protest and dissent is policed, the miners' strike is a useful starting point for us in that discussion. As many of you will be aware, thousands of pickets and their supporters were arrested during the strike, often violently. They were subject to blanket bail conditions which severely restricted their freedom of movement, and some went on to be charged with serious criminal offences, including, of course, the 95 pickets who were charged with riot and unlawful assembly following the Battle of Orgreave in June 1984. Now I'm from a mining community. My family were very heavily involved in the miners' strike, and the memories of that strike are very much alive in those communities today. And alongside the testimony of those who were involved in the strike, there's also a rich body of academic literature which illustrates just how central the process of criminalisation was to the policing of the entire dispute. It describes how arrest and bail not only physically prevented pickets from continuing to be actively involved in the strike, but in relying upon both the police and other state institutions, the courts, the media and the prisons, for example, the government attempted to redefine protest and picketing as criminality, and in doing so sought to win public approval for what was really a political decision to crush the trade union movement. Now, the miners' strike was a seminal moment in the policing of dissent in Britain. It led to the creation of a whole host of new criminal offences and police powers to make it essentially even easier to arrest and charge individuals involved in protest. And it led to important developments in policing tactics. And these events, of course, have come into public consciousness again in recent years as a result of the campaign by the Orgreave Truth and Justice campaign, who've called for a public inquiry into the policing of the strike. And I think the government's response to that campaign is really quite telling. In 2016, the then Home Secretary, Amber Rudd, claimed that the miners' strike is essentially irrelevant to how protest is policed in the current era. As you can see here, she claimed that the policing landscape has, in her words, changed fundamentally since the miners' strike, and therefore very few lessons can be learnt from a review of practices and events of 3 decades ago. Now, given what's continuing to unravel about the level of state interference in protest movements and what is now known about the level of good government interference into the policing of that dispute, I think there are quite good reasons why a Conservative Home Secretary might want to avoid a public inquiry into the miners' strike at any cost. But actually, this idea that there's been a progressive shift in how the state responds to protest is reflected in much recent academic work in the area. We often hear of protesters enjoying rights and freedoms which were previously denied to them, protest policing being less now about state repression and more about dialogue, facilitation, negotiation, and striving to achieve an appropriate balance between competing rights and interests. And this takes me to our recent work on the policing of the anti-fracking movement, because as anyone who's actually been involved in those protests will tell you, this characterisation simply doesn't reflect the reality of what's happening on the ground. And in fact, when we consider the scale and intensity of that policing operation, it suggests perhaps a greater concern with facilitating the profits of the fracking industry than the rights of individuals and communities to protest peacefully. Hundreds of anti-fracking protesters have been arrested, often violently. Many have been given blanket bail conditions, preventing them from attending further protests, and some have been sent to prison. And despite claims that the miners' strike is irrelevant to how protest and dissent is policed today, the process of criminalisation is as important to legitimising that violent response as it was during the strike. And if we take the Barton Moss Community Protection Camp in Greater Manchester, for example, my colleagues and I monitored the policing response to this camp. We interviewed many people who were involved, but significantly we also tracked what happened in the criminal cases which emerged from the camp. So what happened after people were arrested and charged with offences. And the Barton Moss protest became in many ways a testing ground for the policing response to anti-fracking protests that we've seen across the country. During the course of this protest, 231 protesters were arrested for offences ranging from aggravated trespass and obstruction of the highway through to more serious offences such as threats to kill. And just as we saw during the miners' strike, the fact that so many people had been arrested, and in some cases for serious offences, this was used by the police repeatedly to portray the whole movement is inherently violent. As you can see here, regular press releases from the police spoke of violence and intimidation by protesters towards workers, police officers and local residents, with the occasional statement about the risk of mass casualties for good measure. The reality, as we demonstrated in our research, was quite different. Around 98% of arrests were for non-violent offences, and around 2/3 of cases were dropped before charge. But the fact that the police were able to draw on such a wide range of legal powers available to them to make arrests enabled them to present what was an overwhelmingly peaceful protest as one which was characterised by violence, criminality and extremism, and that's a pattern that we've seen repeated at fracking sites across the country. So when footage emerges, as it frequently has, of police officers pinning women to the ground, dragging children into police vans, grabbing protesters by the throat and so on, the construction of anti-fracking protesters as violent and posing a serious risk and a threat to public safety has given some legitimacy to that response. And of course, this process of criminalisation, as we've heard today, is inherently political. The anti-fracking movement is up against a multi-billion-pound global industry backed by the UK government. And as my colleagues and I have argued, this context has shaped how anti-fracking protest has been policed. And as we've heard already, the Stansted case has to be located within the broader context of state racism and the so-called hostile environment policy. Writing back in 1981, Stuart Hall and Phil Scraton put it in the following terms: criminalisation, they suggest, can provide the justification for political containment. It's a particularly powerful weapon when used in this way because it mobilises considerable popular approval and legitimacy behind the state. People are more likely to support state action against a criminal act than they would the use of law to repress a political cause. And as we see in the Stansted case, policing powers have strengthened significantly since the miners' strike. In a process that Paddy Hilliard has described as the normalisation of exceptional measures, a range of criminal offences justified at their introduction as dealing with very different forms of behaviour, so terrorism, antisocial behaviour, harassment and so on, have added to the arsenal of powers available to the state to criminalise dissent. And this is, of course, on top of the broader expansion of public order law, dedicated public order offences that we saw in the aftermath of the 1984-5 miners' strike. So Amber Road is clearly wrong that there are no lessons that can be learned from the policing of the strike, because that process of criminalisation that we saw during that period is as important now as it was back in 1984. But of course there is perhaps another important lesson that can be taken from the experiences of the miners' strike, and that's perhaps a lesson that those in power would prefer that we didn't think about. And that's the importance of collective action, of solidarity and resistance. During the miners' strike, lawyers, academics, trade unionists striking miners and their families and communities worked collectively to monitor police tactics, to provide support and solidarity to those arrested. In the case of the Orgreave pickets that I mentioned at the beginning of the talk, this solidarity eventually led to their acquittal after they were able to show that police officers had lied in court and fabricated evidence. In the case of the fracking three, who were jailed for public nuisance last year after their involvement in direct action protest at the Preston New Road fracking site in Lancashire, it led to their release from prison on appeal amid revelations, as you probably read about the trial judge's family links to the fracking industry. So defence campaigns, court solidarity and events such as these are as important now as they were during the strike, as is working with campaigning lawyers who recognise that cases such as this are won both inside and outside of the courtroom. But I wanted to conclude on the role that academics can play in all of this, because academics can and have played an important role in speaking truth to power and exposing the violence of the state. But it's important to also recognise that academics can play a role in legitimising that violence. As many of you will be aware, it's increasingly difficult to do research on policing and researching state institutions more generally without working in collaboration or partnership, as it's often referred to, with the police or other state agencies. And as Gracie pointed out, those who refuse to do that or present an alternative narrative to the one that's presented by the state will often see their findings maligned, in some cases presented as extremists or terrorist sympathisers. They struggle to secure funding and struggle in some cases to secure permanent academic posts. And this is in the context of a broader attack on academic freedom, which has been brought about as a result of the Prevent strategy and other structural changes in higher education, which mean it's increasingly difficult for academics to work outside of this logic. But as centres like this, I think, demonstrate, spaces of resistance can be found. So when those in power talk about violence and terrorism, we can continue to expose the violence and terror of deportation, of racism, of austerity, of war, of environmental degradation, and so on. So solidarity is key. I think we need to continue to support the Stansted activists in their ongoing campaign. We need to support the Orgreave campaigners in the fight for a public inquiry, and we need to continue to resist any attempt by the state to criminalise dissent. And I think I'll leave that there. Thank you very much.
Excellent, thank you very much. That has raised lots of questions and comments in my own head, so I'm sure there are plenty from the audience as well. We've kind of covered the history of the environment in which we're operating. We've covered the specifics of the case. We've covered the legal issues involved. And I think it's given us a nice kind of granulated, wide view of this particular case, but also the crimes which the Stansted 15 are resisting against. But I'd like to open it up now to the floor. If you can give us an affiliation if you have one, and also if your question is for a specific member of the panel, to let us know. And we'll take a couple of questions in one by one at the beginning, but if we start to get lots, I might have to take a group of questions. So I have a question here, here, and here. So we'll start here.
Thank you. My name is Mohammed Almazi. I write with The Canary, which is a left progressive online news magazine publication, and also volunteer with the Campaign Against Criminalising Communities, which is an umbrella group that came into existence to oppose the Terrorism Act 2000, and since then all the subsequent pieces of legislation. So first question is for Raj. I'd actually really like to hear about the basis upon which the judge did, and more generally can, take away defences from juries. Was that always a power here in this country, that a judge can go to a jury and say, you're not allowed to consider this defence that they've put before you, rather than just telling them what the law is and saying, you decide if this defence applies? And then the other one, I suppose, isn't a question, it's more of a comment about to Dr. Joanna Gilmore. which is an excellent presentation from all of you, by the way. I would push back slightly against the idea that we started off with lots of rights that have slowly and steadily decreased, although I used to think that when I first came here and studied law in 2001. I would say it's more cyclical, where lots of the powers and restrictions on speech and protest and assembly have existed, targeting the Irish, targeting people in colonies with sedition acts and what have you, targeting working class groups within Britain during industrialization, and that they have come and then gone and come and then gone, rather than it starting off, shall we say, more pure and then making its way to where we are now. I'll leave it there. Thanks.
Yes, the judges have always had a power to, in effect, withdraw a matter from the jury if, in their view, having considered the evidence at its highest, that the jury couldn't find the defence made out, in effect. Now, as to why the judge in this case decided to withdraw the justification defences, well, he didn't give any reasons, and we have been pushing for a reasoned judgment, because it would assist in the Court of Appeal, and Ali doesn't even know this yet. Until late yesterday, we didn't have any, and he has just sent through the reasons which because I've been in court, I haven't been able to consider in any detail. Broadly, for justification defences to succeed, they have to have a degree of imminence about the danger, and the prosecution made a big play saying, yeah, but what could have happened between Stansted Airport and Lagos? You never know, somebody else, the police, somebody else might have got involved, so that it wasn't inevitable, in effect, that somebody would come to harm that was on the plane. That was one argument. And the second argument was the issue of whether there were any alternatives to the action that you took. Why didn't you contact the police themselves? Why didn't you contact your local MP? Again, it's a nonsensical argument when you think it through, that when the actor themselves, the state, is responsible for the action, it is exceptional. It's not a menu for anyone to do whatever they want at any point. But in exceptional circumstances, it is surely right that a citizen can intervene to prevent harm being conducted with the collusion of the state, and that will remain the position that we argue for.
Yes, so on the point of criminalisation, I agree. I don't think it is the case that we've ever had this sort of golden age of respect for protest and dissent, and that things have got worse. I think clearly what has happened in recent years, certainly since the miners' strike, is that the scale of laws available to criminalise protest has undoubtedly extended significantly. So there are far more public order offences available, there are far more powers available that have been introduced generally in the context of terrorism and antisocial behaviour, harassment and so on, that can be used to criminalise protest. And I think what it does is to raise bigger questions about the role that law plays within sort of a liberal democracy, because we often see abuses of state power as some sort of departure from the rule of law, but what we've seen in these cases is that law is itself the vehicle by which state violence is legitimised. We saw that during the miners' strike, where the striking miners were arrested for offences that hadn't been used for decades. They drew upon any sort of legal power available to them to justify what was a sort of political decision to prevent pickets from assembling. And at the anti-fracking protest, we saw clearly, as the work of Netpol and other groups have pointed out, what was clearly a decision, the way that strategy was designed was to prevent anti-fracking protesters from disrupting the activities of the fracking industry. And the police relied upon the broad range of powers available to them to do that. So when they arrested people, for example, for obstruction of the highway, those cases collapsed. They then started arresting people for aggravated trespass, and they used whatever powers were available to them. And I think that's something that we've always seen. But I would argue that the scale of law available to the state to legitimise that violence and that political policing has expanded. So that's the point I was trying to make, rather than it's sort of progressively got worse in terms of what the state does and how it responds to protest.
Thank you.
My name is Anna Dunda. I am a visiting student here at Queen Mary University. And I am French, which I think will be relevant to the question that I'm going to ask to Mr. Chada. My question is, so you are going to launch an appeal to appeal the decision, right? What are you expecting from the Court of Appeal? This is my first question. And would you be willing to take this case to the European Court of Human Rights, given that, from what I understood, what you said about the UK judge deciding to put aside some pieces of evidence from the jury, given that the state is both judge and party, because as you said it very eloquently, it's actually the Home Office that is being illegal in this matter. What are your thoughts on the violation of a right to due process, but also the violation of Article 2 of the European Convention on Human Rights, right to life, the prohibition of inhuman and cruel treatment? Have you been thinking about taking this case to the European Court of Human Rights, which could have an impact on all of these questions throughout Europe?
The defendants, in my view, did not get a fair trial at Chelmsford. One of the other grounds, and I won't get into the detail, is that the judge was biased against them. And that's a whole other conversation which we can get into. We think we've got very, very strong grounds to win in the Court of Appeal on a number of issues. I've never been involved in a case where the documentation in the Court of Appeal is about 150 pages and there's something like 30 grounds. It's quite astonishing. My concern is this, the Court of Appeal at the minute is an inherently conservative institution. And whether we, as you say, we could get a proper, fair legal hearing in the Court of Appeal. I think the legal reasoning is very good, and we should do. But the justification issue is the prime example. Justification is a defence that I run on numerous occasions. Sometimes we've won, sometimes we haven't. But the consensus amongst the small group of lawyers that do this type of work is, do not appeal anything, because you will lose in the Court of Appeal. Because things that were tolerated in the Court of Appeal in the 90s, and some helpful judgments that do exist in this area, the Court of Appeal are looking for a reason to overturn it. Now, slowly, bit by bit, they've chipped away at justification. And defences that we used to be able to run, we cannot run anymore. And I think the time has come to put this in and fight it in the Court of Appeal. And if we lose, we will go to the Supreme Court. Well, I'm saying we will. We'll have to wait what the QC says. And if necessary, Europe.
Because I totally understand that lives are online, and I do hope that the Court of Appeal stops being such a conservative institution and that we win this case. But my point is that if you were to lose at this degree of Court of Appeal, and if you were to bring this case to the European Court of Human Rights, you could change the whole crimes of solidarity throughout the whole Europe, France, Italy, you name it. It could be huge.
We hope, first of all, just to get these defendants acquitted.
Absolutely.
But there is a risk in taking this further, justification defence. The risk is that having chipped away so much, they destroy it completely. And that's a conversation that we have to have, not just with these defendants, but with the wider activist community, about whether this is the right case and how far should we go. But there's also risks in litigation that we lose, and we create precedents that is not helpful to future activists. I think there isn't much more you can say about justification than saying it's the Home Office, hostile environment, and there were people on that plane that shouldn't have been on that plane. If it can't succeed there, when is it going to succeed?
So the question, gentleman over here.
Yes. My name's Frank McGuinness. I'm a practicing barrister at Boeing Court Chambers and an executive member of the London Society of Socialist Lawyers, as well as a co-founding member of the Materialist Lawyers Group. So the starting point is, I think, to echo what Raj said in thanking the 15 comrades. I can't emphasise enough how inspiring what you did is and continues to be. And it's striking. I've been watching this case for a long time as a barrister who shares your politics, I think. I am very interested in the justification element of this, and I was confident that if that defence was put to the jury that you would win. Because standing as I do on the outside, it seems plausible on its face that you prevented people with good asylum claims from being removed, and that it was necessary for you to do what you did in order to prevent them from facing a well-founded fear of persecution. So one of the three questions I was going to ask, I think it's already been touched on by Raj, so I won't ask it, but just to point out that it does raise these very interesting questions about the existing edifice of the law and the extent to which it allows you to make these justification arguments. But I must admit to sympathising with the kind of the reasonable liberals in the British establishment who are tasked with a genuinely difficult case in this case. Because what they would be saying, if they allowed you to put that defence to the jury, is that it was necessary to commit a crime, and to shut down an airport in the way that you did, because charter flights create or engage the necessities of defence. And us lawyers, we're fond of this floodgates argument, and I think, Raj, when you talk about creating a precedent, I think that's in a way that's the dam that we need to break through. Because I think there's a popular flood that's waiting to break through against this hostile environment. I'm not sure if I'm being too playful with my metaphors here, but I really think that the establishment is in a difficult position here, and that I'd be very interested to see the outcome of these tactical decisions about how far to appeal, and going all the way to the Supreme Court. I think intuitively is a good idea. Considering then, Crown and Margaret Jones used to be the high point, the high watermark. I saw, Raj, that you've got a case with these DSEI guns, the ones who were charged with obstructing the highway, and that you've been knocked back in the High Court and you're going to the Supreme Court on that as well. I really think this is the time to pick up this fight. My two questions then, I don't want to go on for too long. The first is to question the function of discipline in these cases, and I think that the judiciary ends up fulfilling this good cop, bad cop function, where they drag you over the coals for the duration of your trial, and then they give you a non-custodial sentence. And indeed, Crown and Jones sort of codifies that, doesn't it? Because it says, plead a non-justification defence, and even if you plead not guilty, we'll give you a con dix. And indeed, I've done a few much lower level protest cases, but that's exactly what's happened. Plead non-justification, say the elements of the offence aren't made out, you inevitably get convicted, but you get con dix, right? And it's the state kind of wrapping its arms around the process and sort of saying, now, we recognise your right to conscientiously object, you've done a bad thing, but we won't send you to prison. And it's a very sensible kind of like almost Freudian maternal, paternal duopoly. So that's the first point, is it disciplinary in function? And the second point is just to point out, I think Empire should feature front and centre in this debate. Draw those material threads together of Empire. Consider that Tony Blair destroyed vast parts of the Middle East and created these swathes of migrants that are coming to our shores. And then consider why this case is so explosive, because it does go right to the heart of Empire. My final point then on that is that the first speaker talked about discrimination, the discrimination of the hostile environment. But of course, discrimination is justified under the Equality Act for a legitimate reason. And that's exactly the state's defence is that they're enforcing their borders. And that is the very big obstacle that we have to overcome. It's the same obstacle that's engaged in this phenomenal trial that you continue to face. So I've rather gone too long, but yeah, just to reiterate how proud we all are of you for your incredible action. Really amazing stuff.
Thank you.
So sorry to reiterate, discipline and empire, those are two.
So, I don't know, Gracie, if you want to address that.
I was trying to detect the question.
Yeah, do you agree that Dissent wraps its arms around discipline? Wraps its arms around Dissent and uses that as a disciplinary function. But the question to you then is, I don't basically you can't really use law to fight this problem because the state is pursuing discrimination. Like the border is inherently discriminatory.
Yep. I mean, that's still not quite a question. I mean, I agree, but I also, I mean, I'm not a lawyer and wouldn't advocate law in dismantling the hostile environment. I think you can get to a certain point in campaigning that means that when litigation is brought, the kind of political ground has been laid. That means that actually litigation does kind of get you over the line. I mean, obviously discrimination under the Human Rights Act, some arguments are a bit easier to run than under the Equality Act. But I mean, yeah, I'm not a lawyer, and kind of recourse to law is, to my mind, one tool in a much vaster arsenal. And indeed, kind of being here as a representative of an NGO, I'm kind of like, NGOs are like one small part when we're doing things properly of a much wider whole. If we're not doing it properly, we're making things worse. So yeah, I mean, I completely agree. And I think it can be very difficult when you are part of an NGO. I mean, you know, I don't think Liberty really has a view on empire. I obviously do. But there are certain things that NGOs can't really articulate, and that's why it's really important that other people articulate those things. And it's important that where we can, we work together, as long as, you know, we, with kind of a lot of the money and the power, aren't messing up what other people are trying to do.
Rose, did you say anything?
Very briefly, I think it's echoing what's been said about activists of their role, NGOs of their role, lawyers of their role. And the two examples I always use are the New Cross fire inquiry, in which I think about 30 people died in South London in the 80s. All of the community knew that was an arson and a racist attack. It was never said to be. And it took years of campaigning by activists to get a new inquiry, a new inquest, which got the right result, similar to Hillsborough. But it was the activists that led that and allowed lawyers then to assist. But then look at the states, look at Brown and Board of Education about ending discrimination. Nothing happened until the activists then took that ruling and acted and had civil disobedience in the South to ensure that it was formalised and actually acted upon by public authorities. So everyone has their role to play, and it's about working together to make sure that we fulfil them.
Although arguably the United States is still incredibly segregated, and Brown versus Board of Education was never fully implemented.
Thank you. So we have a question here.
Is it alright if I ask a question to each of the speakers? I'll keep it very brief.
Very briefly. Very briefly.
And it also has to be a question.
It is a question.
I'm going to restrict you to 2 questions if you don't mind. I'm sorry.
Okay, that's fine.
Okay.
I'm Dr. Manish Bhatia from Birkbeck Law School. So my question, the first one is to Gracie and the other one is to Hodge. So in America, whenever they introduced immigration law, draconian immigration laws, Obama did, Bush did, and now Trump has done. And as a result of which we've seen a rapid increase in voluntary, but also forced removals. But we've not seen that since the implementation of hostile environments. So what is the purpose then of, according to you, of hostile environment? What is it achieving? Clearly the creation of surveillance state without no effect makes no sense. So what do you think it's achieving? And my very brief question is, so this trial and charges brought against Stansted 15, I think to me, this is what I think, is guided from what I understand as precautionary logic or preemptive security, which is criminalizing people suspected of causing harm, or in this case, potential of causing harm. Of course, this has required a radical reconfiguration of law and using existing laws in new ways and forms. This also erodes traditional principles and standards of criminal law. So my question to you is, do you think this is becoming some sort of a trend? If yes, what can we do to curtail, limit, challenge this radical reconfiguration of law? that is emerging from the so-called security concerns?
Thank you, and apologies for rationing your question.
Yeah, that's a great question. I suppose one of the other ostensible functions of the hostile environment, it's meant to be a deterrent, so it's kind of meant to stop people from coming. Again, there's no evidence that it does that, because of course what it can't do, or what it refuses to do, and I guess this is a bit to do with the structure of government, because there's no kind of one department that would look at this in a joined up way, which is like, why do people move? Essentially, there's a department that looks at enforcement. You know, you've got the Foreign Office over here, you've got DFID over here. Nobody's looking at why people move. You've just got the department that's essentially tasked with keep people out and try to stop them coming. I mean, if you look at the work of Bridget Anderson, of course, what she would tell us is that borders, and particularly the hostile environment, they're not necessarily about stopping certain things, they're about producing certain kinds of relationships between individuals and between individuals in the state. And so what the hostile environment is obviously doing is it's producing a class of people who have no remedy, you know, when their labour rights are abused, when they're incredibly unwell, when their landlord steals their deposit, you know, when they have a dispute with the teacher at school, you know, when they're victims of serious crimes. So in that sense, it's producing a particular class of people. And I suppose there's an economic analysis that could, you know, talk us through why you would need that class of people, or why it would be in the interest of the state for that class of people to exist. But I mean, I also think that there's just there's a very basic, there's something that's really difficult about the hostile environment, because actually on the face of it looks a lot like common sense. When you consider the common sense that has been kind of produced over recent years, obviously people, you know, shouldn't be able to rent a property if they shouldn't be here. Obviously people shouldn't be able to go to the doctor if they haven't paid into the NHS. Obviously they have been paying into the NHS. Also, it doesn't matter whether or not you've been paying into the NHS. Point to me. So I think a lot of it is just about playing to those people who are saying, and they're powerful voices that are always saying these things, right? There's a very powerful political consensus that cuts across all parties, that cuts across the media, that cuts across, you know, like vast swathes of just, not just the establishment, but just society. And those voices all expect, I mean, I think a lot of those voices and those people would be surprised that these things hadn't been in place the whole time. And I think when you look at the kind of what New Labour did in kind of whipping up that furor around bogus asylum seekers, I mean, they kind of, it was always there. It's been there since, you know, immigration laws are being introduced. When you look at Hansard, it was always about there's too many people who aren't white and we need to stop them coming. But yeah, I think that's been increasingly ratcheted up, you know, in the name of vote winning, among other things. And there's no way to put that back in the bottle. I mean, obviously, like, these are really deep social things that we couldn't just put back in the bottle. But I think they're now like, right, so now we've created, like, undocumented immigration. Migration Watch is saying there's millions of people. This is the reason the NHS is crumbling. I mean, that's the other function of it, right? That when your public services are crumbling, it's important to have something to blame that isn't those services not being funded properly. So I think it serves a multitude of functions, and that's why I think it's really important not to assume that immigration controls are just about immigration or about stopping people from moving, because they're clearly doing a lot more than that.
And the next
I think the reality is that whoever you are, you look and see what powers you have, and then you try and utilise them in whatever way you're tasked to do. So the police will do the same, defence lawyers will do the same. If we're given the ability to do something, cross-examine in a particular way, we'll do that. So what the police are currently doing sort of goes back to what Joanna said. You know, you look and see what the current range of available powers are, and then you pick them out. And that's what they're doing. And all we know on Stansted we've got from an FOI is that a barrister put forward an advice to the CPS, charged 1,800 quid, and recommended this charge. And you know, that's what happens. As soon as you put it on the statute book, give discretion to someone will use it at some point.
Thank you. So we're going to take a group of questions. I'll come back to you. I'm going to take a group of questions from here. The gentleman at the back.
Yeah, my name's Kevin Lyle. I'm the coordinator for a group called the Network for Peace Military. Joanna mentioned that we've done some work with the policing and anti-trafficking process over the last 4 years. I speak to campaigners from local social movements around the country every week who've been described in one way, one form or another as extremists. From environmental campaigners, animal rights activists, hunt saps, anti-fascists. And one of the interesting common threads that comes from those conversations is people saying, I do not understand why they're seeing this in these terms. And I think what was really helpful in Joanna's presentation was to be reminded of the slide with Stuart Hall and Phil Strader's on there, that the reason why this happens is because it is about generating public support and sympathy for cracking down and disrupting many of these political movements because they are challenging corporate, state, or, in the case of animal rights activists, landowners. So my question is, at a moment when this country seems to have collectively lost its mind over the issue of migration, do you think that migrant solidarity and that particular area of work is about to become the new kind of key domestic extremism, if you like, that the government is about to target? I mean, I have a view on this, obviously, but I'm really interested to know what your answer is.
I don't know, how can you decide to say what the government's going to do or not? But I think it's a key area people need to be doing things. I think, like, before this, the action I did before this was around Heathrow and climate change. There's a lot of climate change activists who are very keen to do things, be useful, put their bodies in positions of risking arrest, but they can and have lost sight of some of the wider political reasons for doing that. Like, I care about climate change for a number of reasons. I don't really care about the science about it, I understand it, but what I care about is people's lives and how that is totally linked to migration, it's totally linked to empire, it's totally linked to corporate power, and people are going to be facing much more movement and much more militarization of borders because of that. So I think climate activists should be doing more migrant solidarity, and I hope we're seeing some of that. So I hope people do more migrant solidarity. If the state represses it, that's because they see it as a threat.
Okay, I'm Katie and I'm with an organisation called Migration Exchange, and it's an informal network of funders. So I'm really interested in kind of working out what I should be doing in my work to support migrant solidarity. So yeah, for next time. But so I have like 2 questions, if that's okay. One is super brief, and it might be my ignorance as to why I don't really understand GDPR. But Gracie, you mentioned the whole like data sharing. Does that not contravene GDPR?
This is the bane of my life, but carry on.
I guess the second question is to everybody, you know, as someone who works professionally in kind of migrants' rights in the UK, but also as a private citizen who really cares about it, like, not so much as a cause to action, but everything you're talking about, you know, like the day that the sentence was handed out, there was a charter flight. Like, that makes me feel semi-angry, but also helpless, and I don't know what I should be doing. So I agree that I think all different actors and all sectors have their different roles to play, so I guess it would just be really interesting to hear, like, what next? Is there advice on what we could be doing, what you guys can do? Just as I think all of us have different hats here, so it would be great to kind of hear that.
I'll be really brief. I never thought I would know as much about data protection as I do. I'm sad about it, but here we are. So I've just written a report called Care Don't Share, and it's basically about all of this data sharing stuff. But the very brief answer is that A, so much to do with being undocumented is criminalised. So in the old Data Protection Act, there was an exemption that was to do with being able to set aside people's data protection rights when the data was being processed for kind of crime investigation reasons, for the prevention and detection of crime. So that's how the secrecy around the tracing arrangements for undocumented migrants worked previously. Still not sure that it was lawful, but that was kind of why data protection law wasn't much help. But what the government did, in its infinite wisdom, is, so the GDPR has direct effect, but the new Data Protection Act is in theory meant to supplement the GDPR. The government put in there an exemption to data protection rights where, when a person's data is being processed for the maintenance of effective immigration control or the detection or investigation of activities that would undermine effective immigration control. Now, this was a fun controversy because throughout the debates I said, what will you need this exemption for? You already have a crime exemption. Why do you need this one? The government basically said, oh, if we're trying to trace an undocumented child who hasn't committed an offence, they could already have done that. And they said, oh, if somebody, tips us off and we don't want to reveal the source of the tip-off if someone makes a subject access request, for that also could have been done under the crime exemption. Of course, what we found out, I think last week, 2 weeks ago, is that they're basically running a massive migrant database called the Status Checking Project that basically wants to be able to allow sort of landlords, health services, law enforcement to basically check someone's immigration status at the click of a button, which will kind of exponentially increase the scope and ease with which the hostile environment is enacted. I think the exemption is unlawful. It is currently being challenged in the courts, but basically that's what happened. And it was at the height of the Windrush scandal, parliamentarians, despite knowing that people's landing cards had been destroyed, despite knowing that this basically clusterfucking kind of Home Office data processing was happening and was coming to light, they voted anyway to hand that exemption over because politically that is where we are. So yeah.
I guess I would echo that, different actors have to find their own role. I think all people, all organisations, types of work has a role in migrant solidarity. I obviously have a bias towards taking direct action. I think it's a useful tool, but I think we have to recognise not everyone can do that because of your immigration status, because of family commitments, whatever. But the 15 of us aren't the only people who did that action. There was a huge network of people involved. There was the people who did the media on the day, the people who cooked us food and helped us with our training. There's people who've been supporting us through a 10-week trial. The support is huge, and all of that is really relevant and necessary to take action and to take care of each other while doing that. There's lots of great organisations out there. You could get involved in visiting groups who go to detention centres. It's really important to go give people practical support. So detaining support is one example. There's just so many different groups to get out and get involved with. Anti-Raids is another great network that is in different boroughs of London. It's basically about knowing what to do when an immigration raid happens, and knowing how to give the information to the people who are being stopped to say that you can, most of the time, just walk away. They don't actually have the power to arrest you. I would say that fundamentally I'm against borders. Borders are racist, colonial, sexist, and about capitalism. They're about the rights of corporations to go and extract labour and resources, but not people to go where they want. Further, to be a world with no borders, to me that means a world with no states. So I think legal routes are fundamentally limited, but we can chip away at them. We just need to make sure we're not reinforcing things while we're asking for reforms.
Okay, we're over time. I was going to say running out of time. We're over time, and so if anyone does need to leave, nobody will be offended at all. I'm going to take 2 questions at the end. I'm sorry I won't have time for your question. Okay, I'll take a comment. Very brief, concise questions, and then I'm hoping the speakers will be able to hang around for about 10 minutes, 15 minutes afterwards. So if you have any other burning questions you didn't get a chance to ask, you can ask them, or you can get some contact details and send them a longer question. So first, Professor Kerber. No, you're okay. Question over here then.
I have two questions, but one is a yes or no question.
Okay,
I think it might.
great.
Will this be accessible?
Yep, that'll be online. The video, it'll go on our YouTube channel, and we will probably send an email out afterwards to everyone.
And my second question, so I'm a PhD student from Belgium. I'm also doing a visiting research stay here, and I work on political crimes, so crimes that are committed for a political purpose. And so you might know, but across Europe there used to be very much protected crimes, and I see them as the right to rebel, basically. And I was wondering if in the UK there is such a category of crime. So this would be for you too. So Joanna and Raj, whoever has an answer. And I was wondering if there's such a category of crime in the UK, and if not, if there's something similar.
Sorry, I'll just take the comment as well.
It was just kind of drawing in just an idea that I had. My name's Tanya, I'm a member of the public and a friend of Quaku Adebayo, who some of you will have heard of. Just drawing in the citizen stripping, someone that might have the right to another citizenship, crimes against the country and Sajid. Trying to draw it in and to see if there's a way that he could be prosecuted for what he's doing to our country and therefore have his citizenship stripped.
Excellent, thank you. So the right to rebel.
In terms of is there a sort of law which protects that? Well, the answer is no. I mean, we have sort of limited rights. It would be a much broader discussion to talk about the sort of impact of human rights and how limited they are in the context of public protest and how difficult it is to use those in a criminal case. I mean, what we have, and I think Raj touched on this, is often it's the case that defences are raised in the context of the sort of indeterminacy of law. And one of the most significant and important victories, I think, in recent years is a case many of you probably haven't heard of. And this was the case of the Rotherham 12 back in 2016, which was an incredible victory in which 12 men of Kashmiri heritage in Rotherham, South Yorkshire, in the context of a child abuse scandal, were forced to defend their communities against intense provocation from the far right, who sort of staged weekly demonstrations in the communities and attacked children and young people and so on. And 12 men were charged with violent disorder, and if they were convicted, they would have been sentenced to quite lengthy sentences of imprisonment, drawing upon the precedent set in the Bradford riot cases. And the pressure to plead guilty in that case was so intense. I mean, it's difficult to overemphasise just how terrifying an ordeal it is, which is why we need to have so much respect for the inspirational campaign of the Stansted cases. But there was such intense pressure to plead guilty in that case. But they were supported by the Orgreave campaigners and a whole host of other people who defended similar cases. The Bradford defendants came along as well. And there was an incredible defence where essentially in Garden Court Chambers, I think the barrister there's left, but they were involved in the case, and basically ran a defence of self-defence, where they said that the police had failed to protect communities from fascism, and these people were forced to come out onto the streets to defend their communities and protest against the far right. And they won, and it was incredible. It was an absolutely incredible victory with an all-white jury. Next door to that case was the trial of 12 men charged with child sex abuse scandal, with child sexual abuse. So it was a really heavily politicised case, and yet they were able to run this incredible defence and get solidarity in court. They had some incredible lawyers. So they used the sort of indeterminacy of law in that case in order to raise bigger questions about the failure of the police to protect communities from racism, about the nature of racism, and so on. So I think, we don't have that protection, but where we see these sorts of defences run and the sort of political dimensions in these cases coming out is where we sort of see lawyers and activists making use of that sort of those spaces, those vague spaces, indeterminate spaces in the law. So
I'm not sure if that answers your question, but
Thank you.
Okay, thank you very much. I want to thank you all for coming. I think that it's an honour for me to sit on this panel. It's a really important topic, and I think we had an excellent panel and a really excellent discussion afterwards. The video will be online in a few days, and we may have an audio recording of it as well. But all that remains is to apologise slightly for overrunning. I've reneged my obligations as a chair, but all that remains is to thank the panel for their excellent.